There's a moment in every courtroom drama where the music would normally swell, the camera would zoom, and someone would gasp. This wasn't that. This was worse. This was the kind of moment where the room goes so quiet you can hear your own heartbeat and you realize something irreversible has just happened. No shouting. No theatrics. Just a judge going completely still and everyone else realizing they're about to have the worst day of their professional lives. Because here's what happened. A microphone that was supposed to be off wasn't. A conversation that should never have existed did. And Judge Caldwell, a man known for being methodical to the point of boredom, stopped an entire federal trial in its tracks and ordered U.S. Marshals to seize the defense's laptop right there in open court, in front of the jury, in front of cameras, in front of attorneys who suddenly understood that the ground had just disappeared beneath their feet. If you've been watching the clips floating around online, you've seen the moment. The stillness, the confusion, the look on the lead defense attorney's face when he realizes this isn't a misunderstanding. This isn't a warning. This is a judge telling him, without raising his voice, that his life just split into a before and an after. And the question everyone's asking is simple. What did Judge Caldwell hear that made him do something judges almost never do? Let's back up, because this didn't come out of nowhere, even though it looks like it did. This case was already a pressure cooker. High-profile fraud, millions of dollars, names that make donors nervous and phone calls go unanswered. The kind of trial where everyone walks a little more carefully and every ruling gets dissected like it's a Supreme Court opinion. Judge Caldwell had been presiding for 3 months. 3 months of aggressive defense tactics. 3 months of objections that seemed almost clairvoyant. 3 months of witnesses who, oddly, started sounding less sure of things the closer they got to the stand. People noticed. Prosecutors noticed. Clerks noticed. Even the jury noticed. The defense always seemed one step ahead, like they were playing chess with tomorrow's newspaper. But suspicion isn't proof. Judges don't get to act on vibes. And Caldwell didn't. He waited. He ruled narrowly. He kept the trial moving, outwardly calm. Inwardly, according to people who know him, increasingly uneasy. Then came Tuesday morning. Courtroom 4B, a routine 15-minute recess. The jury files out. Lawyers do what lawyers always do. They huddle. They whisper. They assume privacy because that's what everyone assumes during a break. And that assumption is what ended everything. The courtroom audio system, installed years ago for accessibility and record-keeping, is designed to activate only certain zones during active proceedings. During recess, it's supposed to go dormant. Supposed to. For reasons that are still under investigation, the microphone at the defense table stayed live, and it recorded everything. Not muffled, not garbled. Clear enough that when the audio hit the clerk's office, there was no question what they were hearing. The lead defense attorney, Harrison, speaking in low tones, confirming that a witness had changed her story. "We have the new version. They don't know she talked to us," another voice responds. Not a paralegal. Not another attorney anyone recognizes. Someone who shouldn't have been part of that conversation at all. She's scared. She'll say what we told her to say. Just make sure the judge doesn't find out about the contact. And then the line that reportedly made everyone in the clerk's office stop breathing. Caldwell won't know until it's too late. Within 60 seconds, the recording was in the judge's chambers. Judge Caldwell listened once. Then he stood up, walked back into the courtroom, and did something that terrified everyone who knows how the system works. He didn't react emotionally. He didn't stall. He didn't call for argument. He went cold. No anger, no disbelief, just complete, unnerving calm. He took the bench, looked at the defense table. "Mr. Harrison," he said evenly, "please remain seated." Harrison stood anyway, reflexively, years of instinct kicking in. "Your Honor," I said, "remain seated." That's when the marshals moved, not toward the defendant, toward the laptop sitting open on the defense table. "You can't be serious," Harrison said, his voice cracking. "This is outrageous." "What's outrageous," Judge Caldwell replied, "is what I just heard on the courtroom audio feed." The words hit the room like a dropped plate. He ordered the laptop seized, then the phones, then the tablets, then the external drives. Every electronic device brought into that courtroom by the defense team was bagged and tagged while the jury was rushed out and the prosecution sat frozen, trying to understand how a normal morning had turned into a legal earthquake. But Caldwell wasn't done. "This trial is suspended pending investigation," he said. "All defense counsel are ordered not to contact the defendant, any witnesses, or each other until further notice." That's when Harrison's face went white. Not pale. White. The color drains out when you realize the thing you've been telling yourself couldn't possibly happen just did. "Our client has rights," Harrison managed. "Your client's rights are not the issue, counselor," Caldwell replied. "Your conduct is." And then came the sentence that made every attorney in that building understand exactly how serious this was. "Federal marshals will escort you to processing. You are not under arrest at this time, but obstruction of justice, witness tampering, and conspiracy charges are being evaluated. Not threatened, evaluated." That's a judge telling you the machine has already started. The courtroom went silent because everyone understood what had just occurred. A federal judge had caught what he believed to be active witness tampering on tape in his courtroom during his trial and responded with the judicial equivalent of a nuclear strike. Now, if you're thinking this sounds extreme, you're not wrong. Judges almost never seize defense materials in open court. Attorney-client privilege is sacred. It's the backbone of the adversarial system. You don't touch it lightly, which is why the reaction to this has been so explosive. Defense advocacy groups immediately went on offense. Statements flew. The seizure of privileged materials without a warrant is a dangerous precedent. A judge acting on emotion rather than law. The Fourth Amendment, due process, the rule of law itself under threat. And honestly, on the surface, those arguments aren't crazy. Was the recording legal? The microphone wasn't supposed to be active. Does that matter? Does expectation of privacy apply in a federal courtroom? Can a judge seize devices without a separate warrant? Legal Twitter has been a bloodbath. Half the lawyers are calling Caldwell a hero. Half are calling him a tyrant in a robe. Cable news panels are screaming at each other like it's a reality show. "Judges don't get to be prosecutors," one critic said. He heard something he didn't like and destroyed a defense team on the spot. But here's what complicates that neat argument. This didn't happen in a vacuum. Weeks before this blow-up, there were warning signs everywhere. Take Maria Delgado, former accountant, scheduled to testify about falsified records that went straight to the heart of the prosecution's case. Her deposition was devastating, precise, confident, numbers, dates, documents. The defense was in trouble. Then, 3 weeks before trial, everything changed. Her attorney contacted prosecutors with a revised statement. Suddenly, she was unsure. Maybe she misremembered. Maybe the documents weren't what she thought. The rock-solid testimony turned to fog. Prosecutors raised concerns. Quietly, formally. They told Judge Caldwell something felt off. He acknowledged it, but he couldn't act. Suspicion isn't evidence. Meanwhile, the defense's performance grew more uncanny. Objections landed before questions were finished. Cross-examination seemed tailored to what witnesses hadn't even said yet. It was impressive, too impressive. According to people close to the court, Caldwell told his clerk more than once, "Something isn't right. I can feel it, but I can't move on feelings." That microphone changed everything, because unlike vibes or instincts, audio doesn't lie about what was said. Here's the legal concept at the center of this storm. The crime-fraud exception. Attorney-client privilege does not protect communications made in furtherance of a crime. If a lawyer is helping obstruct justice or tamper with a witness, privilege evaporates. Caldwell clearly believes that's what he heard. And here's the part most people missed while watching the dramatic seizure. Caldwell didn't decide everything in that moment. During the recess, after hearing the recording, he contacted the U.S. Attorney's Office. Quietly. Directly. By the time he returned to the bench, federal investigators were already being looped in. The seizure wasn't impulsive, it was coordinated. Chain of custody was established immediately, legal justification prepared, emergency authority invoked. The public nature of the seizure wasn't for show. It ensured transparency. No quiet backroom confiscation. No later disputes about what was taken or when. That's why some former prosecutors are saying this was surgical, not emotional. Caldwell had been watching this defense team for months. When proof finally dropped into his lap, he acted exactly once, decisively. Still, the risk he took is enormous. Because if he's wrong, if the audio doesn't rise to the level of criminal conduct, if context changes everything, then this becomes a nightmare. Careers destroyed, a defendant left without counsel, a mistrial that can't be undone. And Caldwell knows that. Legal analysts say he essentially bet his entire reputation on this moment. Judges don't make moves like this unless they believe the alternative is worse. Letting a trial proceed while evidence is being manipulated and witnesses are being pressured is the death of justice. Even some defense attorneys are privately admitting that if the recording is as described, this wasn't advocacy. This was participation. But here's where the story gets darker. Instead of laying low, Harrison went outside and held a press conference, an emotional one, accusing Caldwell of judicial tyranny, promising to take this to the Supreme Court, painting himself and his client as victims of a rogue judge. That was gasoline on a fire. Within hours, protesters showed up at the courthouse. Online, the rhetoric escalated. Someone posted Caldwell's home address, his family's names. Threats started appearing, subtle at first, then explicit. The U.S. Marshal Service assigned a protective detail to Judge Caldwell. His wife and children were moved to an undisclosed location. Let that sink in. A judge makes a ruling in open court, and his family has to go into hiding. And here's the bitter irony. The same behavior that allegedly targeted a witness is now being aimed at the judge. Meanwhile, the investigation widened. The seized devices went to the FBI, not a local unit. Public corruption. That alone tells you this is bigger than one trial tactic. Sources are being careful, but they're saying the forensic analysis is revealing significant irregularities. That's lawyer speak for things you don't want found on your devices. There's also the mystery of that second voice on the recording. Not identified, not named in filings, and according to whispers that are getting louder, voice analysis suggests it may belong to someone with ties to law enforcement. If that's true, this story just left the courthouse and entered something much larger. Why was the microphone still on? This system has been in place for over a decade. No prior incidents. Was it really a glitch? Or did someone want that conversation recorded? And why did the defense's strategy shift so dramatically 3 weeks before trial, right when Delgado's testimony changed? Some sources suggest Caldwell was warned about this defense team before the case even started. Warnings he couldn't act on at the time. If that's true, the microphone wasn't the beginning, it was the trigger. Right now, the trial is suspended indefinitely. The defendant remains in custody, bail revoked. Harrison and 2 other attorneys have been suspended pending bar investigations. Their firm has gone dark, phones unanswered, website offline. The devices remain in FBI custody. No timeline, no leaks. And that's almost more unsettling than if there were. Judge Caldwell has filed to keep the full audio under seal, citing sensitivity to ongoing national investigations. National. That word doesn't get used casually. And here's the thing that keeps bothering people who've been around the system a long time. Only parts of the recording have been referenced publicly. The full audio is reportedly longer. What's on the rest of it? This could all end with Caldwell being vindicated, remembered as the judge who refused to let the system be corrupted. Or it could end with appeals, reversals, and a cautionary tale about power and overreach. But there's no rewind, no redo, no quiet fix. A microphone stayed on. A conversation happened, and a judge made a decision that changed everything. The next hearing is weeks away. That's when we'll see whether this case restarts with new counsel or collapses under the weight of what's been uncovered. Either way, the ripple effects are already spreading. Courthouses across the country are auditing their audio systems. Defense attorneys are rethinking how they speak during recess. Judges are watching this closely, wondering what they would have done. Because this case isn't just about one trial. It's about where we draw the line between protecting rights and stopping corruption, between patience and paralysis, between caution and courage. And right now, one judge is standing in the middle of that line, under protection, in silence, waiting for the evidence to speak. If you want to see where this goes, stay with me. Because whatever comes next is going to be bigger than anyone expects.